Good afternoon, everyone. My name is Candice Gomez. I am a co-chair of Schoeneck King's School Law Practice Group. And of course, I am joined by my wonderful co-chair, Kate Reed, today. Kate and I love to meet with clients to conduct trainings on various topics, whether that means in person or this virtual setting that we've now become accustomed to. But this is one topic that we wish we never had to discuss with you, and we wish we never had to talk about with you. Our hearts and prayers, our thoughts and prayers certainly go out to the victims of those impacted by school shootings. And when we heard about the recent shooting in Michigan, Kate and I thought that this was really a time to make sure that our clients had somewhat of a refresher course about these pertinent issues. We certainly want to try to learn as much as we can from these tragedies with the hope of preventing something like this from ever happening again. School safety is a topic that would take at least a week-long conference to really cover properly, but we're hoping that in this short 45 minutes that we have together, we will be able to cover at least some of the fundamental basics. And of course, if you have any questions, please feel free to reach out to us or to the school law attorney that you normally are in contact with at our firm, and we would be happy to walk you through those questions and answers in more detail. So with that being said, if you have any questions along the way, please feel free to drop those questions into the chat or the Q&A box. And as time allows at the end of the webinar, Kate and I will try to address some of those questions. So thank you for joining us today, and we'll go ahead and get started. The November 2021 Michigan school shooting was the impetus for us having this webinar today. So we want to talk through some of the facts as we know them right now. And of course, these facts have not been confirmed. They're based on media reports that may or may not be accurate, and we will only know that once the police have had a chance to do a complete and thorough investigation. But going through the facts we think is important because it can be applied to some of the responses that happen in many of our districts, and we need to think through how we would handle similar situations. Unfortunately, this is not a case where we have a hypothetical that has never happened. It appears to be a real circumstance. But as we said, let's try to figure out what we can learn from this incident to prevent it from happening in the future. So on November 30th, there was a shooting at Oxford High School in Michigan. 4 students were killed and 7 people were injured. There are conflicting reports regarding whether teachers and parents alerted school administrators about the shooter's concerning behavior prior to the day of the school shooting. There have been reports that he had some very troubling social media posts before that day that students were aware of, and their parents reached out to the school principal, but that has yet to be confirmed. On the day of the shooting, a teacher apparently found drawings depicting a wounded person, a gun, and the words, "The thoughts won't stop, help me." And there was another drawing of a bullet with the words "blood everywhere" above it, and a drawing of a bleeding person. These were drawings that were apparently found on the shooter and discovered by a teacher. In response to that discovery, the teacher alerted other school officials, and the alleged shooter was allowed to maintain possession of his backpack, which was apparently never searched for a weapon, while he waited for the school officials to contact his parents. He was removed from class, and as he was waiting for his parents, apparently counselors and different school employees spoke with him, asked him questions about how he felt and whether he believes he might hurt himself or others. And he responded in ways that led the counselors to believe that he did not pose a threat of any harm or danger to himself or others. And the student appeared to be pretty definitive about the fact that he was simply creating these drawings for a video game that he was designing. Once the parents arrived at the school, apparently they spoke with school officials, and school officials told the parents that they needed to get their son into counseling within 48 hours. And the shooter reportedly had no disciplinary record. So based upon the culmination of these facts, the school apparently allowed the student to remain at school after the parents refused to take their son home. They said they had to go back to work. There was no reason for him to have to leave school for the day. And the school officials, unfortunately, allowed the shooter to remain in school and return to class. We'll talk about the things that the school perhaps should have done differently to prevent something like this from occurring. But we know that at least after the school shooting, there have been a number of changes in protocols that maybe we should think about implementing in some of our districts before anything like this were to occur. So they had, at least at some point, a suspicion about backpacks. So as of right now, no backpacks are allowed in the district temporarily. And that's something that can always be done. In some districts, there are clear backpacks so that everyone can see the contents. In other districts, if there's a threat, at least for a temporary time period, no backpacks will be allowed, and that's certainly allowable. The district has also apparently now put software in place that monitors social media activity so that they can have an alert regarding any concerning images or links to websites or any shared items that are basically communicated on the school provided accounts. And to the extent that our districts have the ability to do that, that certainly sounds like a good idea to me, because in many of these cases, we're seeing that there was at least some type of social media activity before the actual event. And to the extent that we can get an alert about that ahead of time, that would certainly be beneficial. And the district now has law enforcement, private security, trained trauma specialists, and all of those staff on site. It, is beyond the ability of most districts to have that type of staffing on an everyday basis, but we should certainly be thinking through our district-wide plans and our building-wide plans about how we have communication and access to those specialists and to those agencies as needed before anything like this were to occur, if for no other reason than to try to prevent some of these acts. And we'll talk more about safety plans later on. I'll turn it over to Kate at this point.
So thanks, Candace. So I think that Candace's recounting of some of the facts that have come to light so far about the tragic situation in Michigan unfortunately raises a number of facts that are concerning about the school district's conduct. My understanding, just from reading news coverage of the tragic events in Michigan, are that there are several members of law enforcement now that are looking at potentially pursuing, if not criminal liability, but civil liability against the school district in question for their failure to respond more zealously to what happened. And obviously, the least of our concerns as we're talking about this topic is frankly liability. The bigger concern is doing what's right, protecting human life. But liability is a concern as well in terms of protecting the school district, protecting all those that are, and empowering those who are in the situation to do something about this sort of situation from having something like this happen in your district or another district in New York State. So one of the most obvious criticisms that's been raised regarding the handling of the situation in Michigan was the student search situation. Reportedly, and again, as Candace said, our knowledge of this situation is based solely on what's been reported in the media, but reportedly, the school district officials actually waited for the family to arrive and then asked for consent to search the child's backpack. Now, as we know now, there was a weapon in the backpack. The child was ultimately released because the parent would not consent to a search, nor would the parent consent to the child being sent home at that time. And the child was sent back to the classroom where ultimately several fatalities were inflicted. So some important takeaway points here. Parent consent is never required to search a child. If you have a suspicion, a reasonable suspicion, which we'll get into a refresher on that topic in a slide or two, but if reasonable suspicion exists, parent consent is not required in order to search a student bag. And one might question what could have happened and what might have happened differently if school officials had not in fact sought parent consent to do the search in Michigan, but in fact had simply gone with their instincts, paid attention to their instincts in that situation and conducted the search that they believed was necessary. Also, an important reminder, parent consent is never required in order to interview a child. So this is a question that we get all the time, which is we want to question a student about a potential violation of the student code of conduct, potential threat of violence, etc., do we need parent consent before we can have the conversation? And the answer is no in New York State. Parent consent is not required for any school official to interview a student. Now, parent consent is required for law enforcement to interview or to seize a student for any particular period of time. So once law enforcement gets involved, that's a different story. Parent consent does have to be obtained, or a warrant needs to be in place in order for that interview to take place. Also statements, another question we get frequently, which is, the student has either admitted to misconduct, admitted to concerning statements, potentially, even if there's not a code of conduct implication, perhaps there's a serious mental health implication, for instance, and the child has made some admissions. Are we required to get parent consent in order to record a statement from the student or ask the student to record their own statement? And the answer is no. Parent consent is not required to obtain a statement from a child. Next slide, please. As a reminder, the only requirements that need to be met in order for a search of a student to be justified is reasonableness. A reasonable suspicion, meaning that the search was reasonably justified at the time of its inception, and reasonably related in scope to the circumstances that justified the interference. So justified at the time of inception would be, was there a reasonable basis, a reasonable suspicion that instituted the need for the search in the first place? In this case, in the tragic situation in Michigan, the facts that Candace reported clearly would be sufficient to meet that test. The fact that the student had made some very alarming statements, the fact that he then qualified those statements by stating that he was simply preparing to create a video game or brainstorming regarding a video game would not negate the need for a search in this situation in the interest of safety. And that search would certainly be justified at its inception. Reasonably related in scope means that the actual scope of the search has to be reasonable to the concern that gave rise to the need for that search. So the example I typically raise when I'm training on this topic is, if you're looking for a weapon, for instance, it wouldn't be appropriate and would not be reasonable in scope to search inside a pill canister in the student's bag, because a weapon can't reasonably fit within a pill canister. In this situation, what would have been reasonable is a search for a weapon, given the concerns raised by the student. And in that situation, it certainly would have been reasonable in scope to search the child's backpack where the weapon was actually located, or to search the child's car, for instance, if there was a reasonable suspicion about the child's car and it was on school property, and also potentially the child's outerwear, etc. So certainly a search that could have remedied the situation, prevented the tragedy that resulted in Michigan, would have been reasonable in this situation. So hindsight being 2020, of course, but we can certainly look back on this and see some areas where the school district could have acted more decisively and potentially staved off the tragedy that occurred. Next slide, please. Now, the reasonable suspicion standard has been contrasted with that of probable cause. You've probably heard probable cause in terms of the law enforcement context. If you follow criminal TV programming, for instance, you've heard that term utilized. You've probably seen it in the news. Probable cause is a higher standard than what's required in order to do a student search. It seems just by reading the news coverage that the Michigan school officials may have been under the assumption that this higher standard of proof applied as opposed to the reasonable suspicion standard. And reasonable suspicion has been defined as simply a moderate chance of finding evidence of wrongdoing, which, as you can see, is not a particularly robust standard. Next slide. Okay, well, I'm going to pass it over to Candace to talk about our red flag law.
Great, thank you, Kate. And one of the things that was troubling about the Michigan circumstance is that apparently law enforcement was not notified until, of course, after this tragic event occurred. And we'll talk more about that later in the presentation, but whenever there's a doubt about violence or criminal activity, contact law enforcement. Even if you believe that there is a slim chance that they'll do anything about the situation, or you just have an inkling that something could be wrong, it's always better to report it and to get that type of expert opinion rather than relying on just hoping that everything will work out okay, because we see that unfortunately it doesn't always happen that way. So please don't hesitate to contact law enforcement if you have suspicions. Red flag law. The red flag law, which is in place in New York, which is a good thing because it's not in place in many states, is designed to keep firearms, rifles, and shotguns out of the hands of students who have been determined by a court to be likely to engage in conduct that would result in serious harm to themselves or others. And some people may wonder why we even need a red flag law, because they may assume that, people under the age of 21, for example, can't legally own a firearm. And that is not the case. In terms of rifles and some types of weapons, the age of being able to own those types of weapons is as low as the age of 16 in New York State. So it does come into play. And beyond the student himself or herself owning the weapon, there's also the danger of having the weapon in the house that is owned by a parent, and that is also covered by the red flag law. So school officials are among the first often to know when someone is experiencing a crisis or exhibiting some type of dangerous behavior. Certainly, in most cases, school employees will know that before the police become involved, before the criminal justice system becomes involved. And it was important for those school employees to be empowered to help take away weapons from students, because in the past, it was simply a matter of maybe a police officer's determination who may not have as much history with the student and may not feel as imminently the types of danger that the school officials were feeling. So prior to this law, school employees did not have a formal way to help take away weapons from students. And this law empowers teachers and administrators to contribute to avoiding preventable deaths from guns. The red flag law has a two-stage process. The first stage, stage one, is gaining a temporary extreme risk protection order. The second stage is getting a final extreme risk protection order, in which the court has a hearing to determine whether the firearm should be taken away from the student or perhaps from the home in which this student is located. If a teacher suspects that a student may pose a risk, we're suggesting that a good protocol would be to, number one, let the building principal know immediately. And if the building principal is not there, there should be a designee, someone else to report that information to that can handle the situation immediately. Because as we see, unfortunately, with the Michigan case, time is of the utmost importance in these types of circumstances. To the extent that you have any evidence, screenshots, notes, any type of social media posts, any type of conversations that other students may have overheard, get all of that together and bring it to the building principal or their designee, and that person will reach out for further direction. Perhaps they will contact the police, perhaps they'll contact legal counsel, but you want to make sure that someone is acting on that information. Only the building principal or other chief school officer is authorized by law to file the application for the temporary extreme risk order. So a teacher would not be able to do that, but a building principal may designate in writing someone else to submit an application, for example, a vice principal or an assistant principal. The protection order can be issued against a current student or someone who's been enrolled within the last 6 months if that person is no longer a current student. And a question that we get asked a lot is this an additional requirement or obligation on school staff? In other words, does this law mandate that school staff report when they suspect a student poses a harm to himself, herself, or others? And no, it's not an additional requirement. It doesn't require that school staff members report this to law enforcement or to the courts, but it is an additional tool meant to help protect the school community. And although this has not been tested, one thing for us to think about is that we see in Michigan, as Kate mentioned, those civil suits are already being filed. And although liability is not our main concern when we're talking about the lives of individuals, even though the red flag law may not be a mandate, we should think about the potential repercussions for those who may be aware that there is a risk at hand and choose not to report it, because there are certainly civil and at times criminal consequences that a person may face by not properly addressing a risky situation that could put the lives of many, many people at risk. Moving on to safety plans, we see that some of this legislation has come on the heels of very significant and tragic incidents. So after the 1999 shooting at Columbine High School, Governor Pataki, who of course was the governor at that time, signed Project SAVE into law. And that required districts to create a district-wide safety plan and a building level plan. A district-wide plan, which I'm sure all of you have heard of, and we hope that you are continuing to look at this plan on a routine basis and keeping it updated, needs to be developed with the consensus of many different people, representatives from the school board, students, teachers, administrators, parent organizations. And I think that's really critical because you're able to see the perspective of different individuals throughout the school community who may have very important information to add. So it's good that we have all of those perspectives. One of the great parts about a district-wide plan, before I move on to the building level plan, is that it is keyed towards prevention. So a lot of people think about these plans basically going into effect in the event of an emergency. Okay, an emergency has happened, now we've got to put the plan into effect. No, we should know what the plan says, and we should be looking at that plan and modifying it every step of the way to make sure that we're using the preventative measures within that plan to avoid an emergency from happening to the extent that we can. And there's a lot of different requirements in those district level plans that are geared towards prevention as opposed to response. Building level plans, similar to the district level plans, are created with a team of individuals from many different walks of life, including law enforcement, of course. And one of the critical differences between a district level plan and a building level plan is that for security reasons, building level emergency response plans are confidential and they are not subject to disclosure under FOIL, the Freedom of Information Law. There are very specific details in that plan that only a very small universe of individuals should have access to. People should not know which doors the students and staff will be exiting from in the event of an active shooter. We would never want that information out to the public, for example, because an active shooter may position themselves at those very doors that are planned as an exit. That must be kept strictly confidential, and that is one of the main differences between a building level and district level plan. I'll turn it to Kate now.
So in the aftermath of the tragedy in Michigan, we've been receiving a number of questions that seek clarification regarding the status of firearms in school and who may actually possess a firearm. So we figured that today's seminar would be a good opportunity to refresh everybody's recollection regarding some of those rules as well. So back in 2019, the law was changed. Prior to that point, anybody who was authorized by the superintendent could actually possess a firearm on school property. The criteria was simply that there was approval by the superintendent. The law was amended in 2019 following the tragic shootings in Parkland, actually, and to make the law more restrictive in several regards. So now there are only certain designated individuals under the penal law who are authorized to carry a firearm on school property. And they include those who are primarily employed as school resource officers, police officers, peace officers, or certain security guards who've been issued special armed guard registration cards. So that would not include all security guards. So a common question we receive is, must a school resource officer be a police officer or retired police officer in order to carry a weapon? And the answer is no, as long as the person is primarily employed as a school resource officer, they would be empowered to carry a weapon. There's good reasons, however, and to only limit school resource officers to law enforcement officers. Chief among them, that these are the individuals in our society that are trained and have specialized training regarding the use of firearms, and also who have typically programs associated with their primary employment or their former employment through either your local county government or city or village government regarding the proper management of firearms. So again, the law was made more restrictive, but school resource officers as well as police officers may still possess weapons on school property. Another question that often comes up around this is, must a school resource officer carry a weapon? The answer is no. That is a local school district decision regarding whether your SRO will carry a weapon. In the situation in Michigan, it's important to note that the news coverage to date reflects that when the school officials questioned the parent and the student, there actually was a school resource officer on site, but the school resource officer was not consulted. Ultimately, the school resource officer did respond to the shooting situation and was able to disarm the individual who had engaged in the violent actions, the student who was armed. So involvement of school resource officers in evaluating threats can also be effective and an important role for your school resource officer as well. Next slide, please. What is important to understand is that if you choose to use an SRO, and particularly if you choose to use an SRO who is armed with a weapon, it is important to note that the regulations and the laws regulating district-wide and building-wide safety plans that Candace just reported on have very clear criteria for how the role of the SRO is supposed to be indicated in those documents. So chief among them, there needs to be a contract with the SRO. Many of you have already moved in this direction last year when you reviewed your district-wide safety plans. I know there are several districts that have not, however, so this is a great thing to flag for compliance as you go through your next cycle of district-wide safety plan review, that you should have an employment contract with the SRO. Now that could be an employment contract with an employed SRO, but it could also be, for instance, an intermunicipal agreement with a local government, a county government or city government, for instance, if you are essentially utilizing the services of an employed police officer to serve as your SRO. In either case, there needs to be a contract that sets forth exactly how the SRO will be responding to situations involving student misconduct, particularly whether they would be enforcing provisions of the code of conduct. So this would also go to the issue of firearms. If the SRO is going to be responsible for being armed, there will be an expectation in the regulations that that contract with the SRO would specify how and when the SRO may carry a weapon and how and when that weapon may be utilized. Similarly, there's a transparency requirement that's included in the new regulations to the district-wide safety plan law, which provides that prior to utilizing an SRO, districts are required to consult with and obtain input from multiple stakeholders. And those stakeholders are listed on the slide, but it's essentially anybody in your community who has a stake in your school community. And that contract with the SRO is required to be based on that stakeholder input. So again, if your SRO is going to be carrying a weapon and has not previously carried a weapon, this is a good thing to flag for compliance in the next district-wide safety plan review cycle, that you would want to make sure that you are soliciting community input, not just from the standpoint of compliance with the regulation, but just as a matter of fundamental transparency as well. Candace and I have previously, I believe, spoken to this group on the topic of preventing the school to prison pipeline, for instance. And there are very strong opinions in not just among parents and stakeholders, but also even in the scholarly literature about the role that armed SROs play in the school to prison pipeline. As a result, many districts have elected not to utilize SROs, and especially not to utilize armed SROs in schools. So before going down that path, there could be strong opinions. Even among safety-minded people, there could still be strong opinions about the value of an armed SRO. And certainly it's something that requires community transparency before rolling it out. And then finally, whatever you develop in terms of a contract with your SRO must then be incorporated into your district-wide safety plan that ultimately gets submitted to the SED. Next slide, please. So we have a quick Q&A, and as Candace mentioned, We aim to be as efficient as possible with our prepared materials here so that we could get to your questions. If there's no questions, we'll let you get back to your regularly scheduled afternoon programming without keeping you here any longer. But we've prepared some questions that have come up in the aftermath of the Michigan school shootings, and some that have come up, some that we envision might come up if you were dealing with a crisis center situation in your school. And one of them is regarding confidentiality of school staff. So I've heard it stated multiple times, mainly by counselors, less by administrators who seem to know this rule, but often by mental health providers in schools. They'll say things such as that the information that is shared by a student is confidential, or they may use the word privilege. They may say, there's a psychologist privilege, for instance, or social worker privilege. That means that I, as a mental health provider, cannot disclose information that is obtained from a counseling situation unless I comply with the rules that would be applicable to a clinical psychological setting. And that is simply false. I don't know where they get that. They must teach them that inaccurate information when they're getting their training, because it comes up all the time. Many therapists believe it, but the rule is actually the opposite. School mental health providers do not have a privileged relationship with students. When they're serving in a school-based environment, the relationship is not considered therapeutic, it's considered school-based. And as a result, there is no privilege. All that applies is FERPA. FERPA provides that information that is confidential about a student can be shared with anybody who has a legitimate educational interest in that information. So in that situation, it may be the case that a school counselor who becomes aware of disturbing or dangerous things that a student is saying would absolutely be empowered to share the information that they learn with school administrators and others who have the ability to respond appropriately. Similarly, we've often heard the question of, well, it's not worth it to go through the discipline process, for instance, in the case of a classified student who has a 504 plan or an IEP, because essentially the district is powerless to remove that student from school in any case based on the manifestation rules. So why should we go through the process? And that's not strictly true either. There are options in the event that a student poses a risk to the school community. So even if they are classified, it is important to go through the process. For the first reason, you may determine through that process that the student has actually making threats that are not a manifestation of their disability. Obviously, if there's no manifestation, there's no impediment to pursuing traditional school-based discipline. Even if there is a manifestation, there are several options that we as your attorneys can help with in terms of removing a child that is dangerous from the school setting. I want to point out here that the red flag law that Candace reported on actually does not provide any mechanism for removing a child from school. The sole purpose of that law is to remove firearms from the child's possession, but not to actually remove the child from school. It was hoped when the law was passed that it would essentially create a procedure to bypass some of the complicated rules around removing students, particularly classified students, from school, but that is not actually the law's purpose. But if a classified student engages in conduct where there's a manifestation between that conduct and their disability, there are several options that the district can still pursue. The district can pursue its own expedited due process hearing in order to have the child's placement changed to an interim alternative educational setting. The threshold for that change of placement is if the student is deemed to be a threat to self or others. So certainly a student, for instance, that was engaging in the type of behavior and conduct as the child in Michigan would certainly hit that threshold in all likelihood. Also, there's a formal court proceeding that is called a Honig injunction. That is another procedure that we may utilize as your counsel to go to court in order to get a dangerous child transferred out of the school setting. What is important is that you utilize your permissive suspension days very carefully in the case of classified students, so that those days are available to you in the event that there is a more serious situation that comes up. Because again, you get those essentially 10 free days. Once you pass the 10 days, you have to abide by all these more complicated procedures in order to remove that classified student from school. The next question relates to health or safety concerns and confidential information again. I have often heard it stated that a health or safety concern automatically allows the disclosure of confidential student information to third parties. I've heard it expressed in the opposite way, which is, isn't it true that even in the case of a health or safety situation, we still do not have the authority to release information? Neither is true. There is a health and safety exception to FERPA, the student confidentiality law. In order to qualify for that exception, a school official needs to make a determination that there is an imminent threat that warrants disclosure of confidential student information. What is required in order to invoke that exception is that the school official record in writing the basis for that decision. And if that recording is made and the decision is made to release information, the United States Education Department will not second guess the school's decision-making in that regard. But it is important that that exception be applicable before disclosures be made. Next slide, please. So just lessons learned, and Candace, jump in here as well, because I don't want to monopolize the conversation, but I think some of our takeaway points here in terms of being more proactive and ensuring that your district doesn't become a district that's in the headlines is that it's important not to ignore the warning signs, especially including social media and off campus. We know that some of the warning signs in the Michigan case involved social media conduct. And we've known also that in other previous school shooting situations, there have been warning signs that have come to light where other students and parents then shared that behavior of the student online really gave them cause for concern. So I think never ignoring those warning signs. If it gives you cause for concern as a school official, chances are you're not overreacting. Chances are there is a reason to be concerned, and it's better to overreact in the case of rolling out a threat assessment versus not reacting adequately enough. And threat assessment also goes to the value in adopting relationships with outside individuals, third parties, who can help you with the process of conducting threat assessments. There are psychological professionals and law enforcement professionals that do this for a living, and they are generally happy to assist schools in making more documented and nuanced threat assessments so that you can not overreact, but at the same time react responsibly. Reviewing district-wide safety plans and building level plans is discussed, particularly if you're going to be transitioning from being a district that has not previously used an armed SRO to being a district that does use an armed SRO. That is something that requires disclosure in your district-wide safety plan. Training your administrators and your principals and those charged with enforcing student conduct on the proper procedures regarding search and seizure. For instance, not requiring parent consent prior to conducting searches. Obtaining stakeholder input prior to implementing armed SRO programs, and as Candace already said, when in doubt, involve law enforcement. Before we turn to the Q&A in the question and answer box, Candace, do you have any other pointers that you'd like to point out as well before we move on?
No, I think what you pointed out was exactly what I would have wanted to share with the group. I see that we have a couple of questions about the red flag law, so I think I will try to return to those slides to maybe talk about that in more detail.
Great.
Okay. All right, so the red flag law. We had a request to return back to this first slide so that it could be digested a bit more. And I understand that there's a lot on the slide and a lot to understand. We've also had a question regarding the circumstances in which a school administrator, a principal, would actually institute this and apply for a temporary extreme risk protection order. So let's look at some of the factors that would need to be present in order for a principal or for legal counsel to advise a principal to go ahead and seek a TRO, a temporary restraining order. Is there a threat of violence, or was there an actual act of violence or physical force that was directed towards a student or a staff member or another person in the school community? If we use the Michigan circumstance as an example, then the answer would be yes, there was a threat based on the drawing that was basically depicted by the student. Just turning to my notes here so I can give you a more comprehensive list. We also need to know if there was a violation or alleged violation of an order of protection. If either one of those were the case, that would also be grounds to seek an extreme risk protection order. If there are any pending charges against the student, that would certainly be justifiable in terms of seeking this protection order. If there was the reckless use, display, or brandishing of a firearms, rifle, or shotgun. I want to talk about that for a moment because, of course, we all know that if we saw a student brandishing a weapon in school, immediately we would not only ask for a protection order, but we would be contacting the police. But I don't want to leave out the fact that there could be a social media post where the student is brandishing a firearm or some type of social media activity that involves the firearm. It doesn't necessarily have to be in person or on school grounds in order to constitute a threat that would justify this type of seeking of the protection order. Whether they have a history of having protection orders in the past would also be a relevant factor. If there's any recent or ongoing abuse of controlled substances or alcohol, that's another factor that the courts will consider in whether or not this protection order should be granted. And of course, whether there's evidence of the recent acquisition of a firearm, rifle, or shotgun, or whether they have access to such an instrument would also be relevant. Keep in mind that although the school official is going to be seeking this protection order, they're not ultimately going to make the determination about whether the order goes into effect. That determination is going to be left to the courts. And I suspect that part of the reason that this red flag law is not used more often is that it does require effort from the schools in terms of having possibly a person serve as a witness. So when the court is determining whether or not to grant this protection order for the school, the court may conduct an examination under oath of a school official or any other witness provided by the school official in order to determine whether there's sufficient evidence to grant this protection order. And we understand that that is concerning. No one ever likes to testify, even when we have routine subpoenas about things that are, very kind of routine and minute. It's difficult to get school officials to testify unless a subpoena or some type of order of the court is issued. So we understand why it may be difficult for people to almost voluntarily request these orders, knowing that they'll have to testify in court. But we can see why it could really be for the benefit of not only that one individual who is testifying and explaining to a judge why this person seems to be a risk, but it could also save the lives of many in the community. So we need to talk more about red flag laws. And I think that although it's a great thing that it's now law, and it has been since 2019, I don't know that it's utilized as much as it could or should be utilized.
Yeah, and that's a great point, Candace. Just anecdotally in my practice, and I principally work with districts here in the upstate New York region, central New York region, but I know in our region of the state, this is not a provision that's utilized very much at all, if at all. I'm not aware of any districts that have filed one of these proceedings, mainly based on the concern that I raised the last time, which is the primary concern, I think, of most school officials when they come across a threat situation is how do we get the student out of the school environment as soon as possible? And this law does not actually facilitate that. It facilitates removal of weapons, but it does not facilitate getting the child out of the school setting. That has to be accomplished through traditional discipline processes. And something else Candace said triggered another point that I want to focus on as well, which is, as we're talking about student discipline options, a question that was recently raised by a school district that will remain unnamed was the question of, do we have the capacity to actually discipline a student for firearm possession that occurs solely off school premises? As you all are likely aware, engaging in behavior off school property doesn't always have a connection or nexus to the district code of conduct. And districts have to tread carefully in disciplining students for behavior and speech that occurs off school property because that discipline may be subject to legal challenge if the student files an appeal. Nonetheless, I did look into that question for that district that had that particular concern because they had had a situation with some students who were caught with weapons off school premises. And we actually did identify some authority and some prior case law where students have been disciplined successfully for off-campus behavior, particularly pertaining to weapons possession, and where our commissioner and the courts have held that that behavior is sufficiently risky to the school environment that it is something that the school may enact discipline for. So tread carefully, I think is what we'll say. If you want to go down that path, but certainly talk to us about it. We may be able to help you get to yes on that, because there is some authority, albeit old authority, as is often the case, but there is some authority that authorizes discipline in that situation. We also had the question in the chat regarding armed SROs, and specifically whether the fact that an SRO will be armed needs to be disclosed to the public. That's the specific issue regarding arming or not arming is not addressed in the regulations, but what is addressed in the regulations is the need for complete disclosure of how the SRO will be involved in performing their functions. And I think intrinsic to that is the concept that if an SRO is going to be carrying a weapon, that is something about which the district would have to solicit stakeholder input. Because every aspect of the SRO relationship with the district is supposed to be subject to stakeholder input. I would also note that, just again, anecdotally, I've worked with several districts here in central New York who have had specific requests from their insurance companies to adopt policy around this point. When the insurance companies have inquired to say, is the SRO carrying a weapon? And the answer has been yes. They have stated not only should there be public disclosure of that, there should actually be a standing board policy identifying how and when force may be used and how and when a weapon may be carried in order to guarantee the school district's insurance coverage in that sort of situation. So both from the standpoint of complying with the regulations, and then also in terms of ensuring adequate insurance coverage in the event of an injury or a death in the event of the use of a weapon, we do recommend that you obtain public disclosure and transparency around the issue of an SRO carrying a weapon. I also think from a public relations standpoint and from a community transparency standpoint, as I stated before, there are serious school to prison pipeline considerations in moving to an armed SRO. If you have not done that previously, you would certainly want to get input from your community and the various people that will be interacting with the SRO before you would go in that direction. So I think that's all the questions we have in the Q&A. Candace and I can certainly wait around here for a few minutes too, if anyone has anything else to add. Candace, did you have anything else you want to add just to our prepared presentation content before we let everybody go?
No, I think we've covered what we can in the time allowed, and certainly we just want this to kind of be at the front of everyone's mind, so that to the extent you have more detailed questions later on, you know that our bond attorneys are here for you to reach out to. We certainly want this to be a priority for every district, and we don't want an incident like this to have to propel us to think about these things more closely. But, in light of what has happened recently, and unfortunately what has happened over the past many years, we want to make sure that our schools are as prepared as possible. So thank you all for all of the great work that you do in our schools, not only educating the students, but keeping our students safe. And we want to do everything that we can to assist you in that regard. So thank you for your time today. And please feel free to reach out to any bond attorneys if you have questions about what we've talked about today. Have a great day.
Thanks, everybody.
Thank you.